at the time of the preamble, and therefore it can possibly have no relevance to the Constitution, to power in the future when that Constitution itself can be changed. The position would be the same so far as the preamble is concerned, whether the constituent power is exercised by the amending body, provided for by the people themselves in the Constitution, or by referendum, if so provided for in the Constitution. Clear constitutional provisions and are imperative both on the legislatures and the core. Where a constitutional provision is comprehensive in SEO and leaves no room for interpretation, the court is without power to amend, add to, or detract from the constitutional provision, or to create exceptions thereof. BF implication. Where the people express themselves in careful and measured terms in framing the Constitution, and they leave little to implications, amendments, or chan, as in the existing order or conditions cannot be left to inserting allocations by reference to the preamble, which is an expression of the intention at the time of the framing of the Constitution. The power to amend the Constitution is therefore not restricted and controlled by the preamble copy. Patu 1, Patu 2, Patu 4, Patu 5. Kesavananda E. Kerala, Ray J. 27 Berubari Call, 1963 SCR 250. Topalan v. State of Madras, 1950, SCR. RD8. Kawamele Tit Lukotian Bill, 1957, 1959, SCR 935. Bajeshiar Nath, VTHCJT, Aditya High, 955, Sup 1 SCR, 528. Coal Beaming Artas Act Cast, 1962. 1 SCR 44, Statef Reistavlit Lorraine, 1965 1 SCR. 276, Secretary of State for India, in Council v. Mamranak of Babel 1, ILRH MAD 529, Attorney GTN Tral v. Prime Ernest Augustus of Hanowar, 1951 J. AC 436, and HNMNG Jacobson v. Commonwealth of Massachusetts 197 US 11 referred to. At the theory of implied limitations is a subtle attempt to annihilate the amative power of amendment. The maxim expressum facit cessare taxtum. One of the salutary principles of statutory construction, Pors 106, R. of Bura, 3 AC 889, WTBB Vutrim, 1907, AC 89, Fielding v. Thomas, 1896, AC 66, Whitman v. Sadera, 1910, AC 514 referred to. The entire approach of the PC Thion CR to the power of AMC DCNT, contained in Article 368, ignores the fact that the object of the Constitution TS, TC provide, or the organs of state, like the judicature, legislature, and the Execute.ivc, for the governance of the country. Great and wide powers are conferred, for the governance by great sovereign countries, and such powers cannot be withheld on IHC ground, that they may be used externally or oppressively. Settled principles of construction in interpreting constitutions preclude limiting the language of the Constitution by political, juristic, or social concepts in DCPCN.
ECNTly of the language of the Constitution to be interpreted, 406-407, DTP Chand v.
Stat of Uttar Pradesh 1959. Supe 2 SCR 8, Kun Fai Bura, 1807, 5 IA. 179, A11 Orntigitian Trial for Ontario Veteran, Ihitin Trial for Canada, Knowing Grudos AC, 571, Gopalan CM, 1950, SCR 88, Kuhan Madamenan v. State of Bombay, 1951, J. SCR 228, and Bhimwari Lal Sharm Case, 72 IA 57, RCF CFR CD 2, all provisions. 00 The Constitution arc essential and no distinction can IGEM. DC between essential and non-essential features from the point of view of amendment, unless the makers of Constitution make it expressly clear in the Constitution itself. The theory of implied and inherent limitation cannot be allowed to act as a boa constrictor to the clear and unambiguous power of amendment. When certain restrictions are imposed in Article 368, it is not intended that other undefined restrictions should be imposed by implication. The provisions of the Constitution, in the hut of historical background and special problems of the country, will show that no provision can be considered non-essential. The character of the provisions which are amendable under the Rovisi to Article 368 itself shows that the petitioner's submission that CSN Sol features arc unum cantabile C is a baseless vision. If there are no indication in the Constitution as to what the essential features are, the task of amending MCNT of the Constitution becomes an unpredictable and indeterminate task. There must be an objective standard by which it can be predicted as to what is essential and what is not cessenial. If Parliament cannot judge these features, Parliament cannot amend the Constitution. pp. Fartsun 7, Fartsun 8, Fartsun 9, Fartsun 10. There is no foundation for the analogy that just as jutig keys test reason, ABL sciences in law, the judicial mind will find out the essential features on the test of reasonableness. Reasonableness in law is treated as an objective criterion on the 8 Supreme Court Reports, 1973. Sub PS. CJLH seek awask reason inheres in man as rational being.